All right, good afternoon. I'm Dean Jessica Berg, and it is my great pleasure to welcome you to this year's Frank J. Battisti Memorial Lecture. The lecture is named after Judge Battisti, who served on the U.S. District Court for the Northern District of Ohio for 33 years and as Chief Judge for most of that time. Although not an alum, Judge Battisti was a great friend of the law school. He hired quite a few of our graduates as his law clerks, and indeed the lecture series came about largely because of the devotion of many of his clerks who helped endow the series. We've had an extraordinary array of distinguished lecturers in the series, both from the law and other fields in which Judge Battisti had an abiding interest. Previous lecturers have included prominent judges, distinguished legal scholars, prominent historians, social scientists, leading religious figures, iconic civil rights figures, and two of Judge Battisti's former clerks. To introduce the Battisti lecturer this year, I present my faculty colleague, Professor Aisha Bell Hardaway, the director of the Social Justice Law Center, who is also the organizer of this event.
Hi, everybody. Welcome. Thank you, Dean Berg. This lecture series, as Dean Berg mentioned, is made possible by the generosity of many of Judge Battisti's former law clerks. At this time, I ask that any of the former law clerks who are in attendance, would you please stand and be recognized? As Dean Berg also mentioned, we've had the great fortune of having some notable lectures in this series, both from law and other fields in which Judge Battisti had an abiding interest. Previous lecturers include Judges Leon Higginbotham, Nathaniel Jones, and Jack Weinstein. Legal scholars Lee Bollinger, Erwin Chemerinsky, and Michael Klarman. Political philosopher Jean Elstein, historian of education Diane Ravitch, and sociologist Douglas Macy. Legendary civil rights figures Julian Bond and our own alum Fred Gray. Religious figures such as Sister Helen Pregine and Bishop Nelson Perez, and two of Judge Battisti's former law clerks who went on to outstanding legal careers, one of which stood up just a bit ago, Judge Marilyn Shea Stoneham, of the U.S. Bankruptcy Court of the Northern District of Ohio, and President Frank Wu of Queens College of the City University of New York, just to name a few. Today's speaker makes a significant and substantial contribution to an already illustrious series. Our Battisti lecturer this year is none other than the Honorable Solomon Oliver Jr. of the U.S. District Court of the Northern District of Ohio. Judge Solomon Oliver Jr. was raised along with his 5 brothers and 4 sisters by his parents in Bessemer, Alabama, where he attended segregated public schools. Judge Oliver was appointed to the U.S. District Court for the Northern District of Ohio by Bill Clinton in 1944 and served as that court's chief judge from 2010 to 2017. Judge Oliver holds a BA from the College of Worcester, a Master of Arts in Political Science from Case Western Reserve University, and a JD from New York University School of Law. Early in his career, he was a law clerk for the late James H. Hasty of the Third Circuit Court of Appeals, the first African-American federal judge. Judge Oliver was an assistant U.S. attorney in the U.S. Attorney's Office for the Northern District of Ohio from 1976 to 1982, where he served as the chief of the Civil Division and chief of the Appellate Litigation Group. From 1982 to 1994, he was a professor at a school down the street. No, he was a professor at Cleveland State University's Cleveland Marshall College of Law, and he served as associate dean at that institution from 1991 to 1994. He served on the Judicial Conference of the United States, the governing body for the federal judiciary, and on its advisory committee for the civil rules and its advisory committee on evidence rules. He's set by designation on the U.S. 3rd, 6th, and 9th Circuit Court of Appeals, and he has served as chair of the American Bar Association Council of the section on legal education and admissions to the bar, He currently serves on the board of National Conference of Bar Examiners. That might matter to some of the students here in the room. For the last 6 years, Judge Oliver has served as a member of the teaching faculty at Harvard Law School's Winter Trial Advocacy Workshop. In 2020, Judge Oliver received the Richard W. Pogue Award for Excellence in Community Leadership and Engagement from the Cleveland Metropolitan Bar Foundation. I was there, some of you were, it was a good night. And in 2018, he was the recipient of the Kutak Award, given annually by the American Bar Association section of Legal Education and Admissions, to an individual who has made significant contributions to the collaboration of the Legal Academy, the Bench, and the Bar. Judge Oliver is the recipient of the Bench Trailblazer Award from the Norman S. Minor Bar Association, and he is the recipient of the Distinguished Alumni Award from our alma mater, the College of Worcester, and the Distinguished Alumni Award from the New York University Black, Latino, Asian Pacific American Law Alumni Association. He's been inducted into the Cleveland Marshall College Law Hall of Fame and the Case Western Reserve University Law School's Society of Benchers, and he's received honorary degrees from the University of Akron and the New England School of Law in Boston. He's a member of the American Law Institute and the American Bar Foundation, as well as the Board of Trustees at the College of Worcester. Would you please join me in giving a very warm welcome to the Honorable Judge Solomon Oliver Jr.
I told her to cut it back, but she wouldn't pay any attention. And I guess my orders at this time don't have much force and effect. So thank you very much, Professor, and thank you, Dean Berg, for your kind welcome. It's indeed an honor to be here with you. I'm honored to be invited to give the Frank J. Battisti Lecture. I had the opportunity to appear before him, Judge Battisti, when I was an assistant U.S. attorney in the late 70s. And we were colleagues for a brief time when I came on the bench in 1994, before his untimely death that year. He was a judge who took seriously Alexander Hamilton's description of judges in the 78th Federalist. He saw judges as faithful guardians of the Constitution. He was willing to make the tough decisions that judges are sometimes called upon to make without being influenced by public opinion. For example, he must have known that his acquittal of the 8 former National Guardsmen who were implicated in the shooting of the 4 Kent State students on May 4th, 1970, would be widely controversial. And while he was honored by some groups for his ostensible courage, for his landmark ruling in Reed versus Rhodes, that Cleveland, a northern city, had engaged in illegal racial segregation, he required constant U.S. Marshal protection for death threats he received as a result of that decision and his remedial busing order. This harkened back to the days when the federal judges involved in ordering school desegregation in the South were threatened with death. Beyond being generally honored to speak at a lecture in honor of my colleague who displayed such courage under pressure, I'm also pleased to be counted among distinguished persons who had previously served as Battisti lecturers. And Professor Bill Holloway talked about some of them. That includes my friend and mentor, the late Judge Nathaniel Jones, who represented the plaintiffs in Reed versus Rhodes. Judge Jones was the first African American to serve as an assistant U.S. attorney in the U.S. Attorney's Office for the Northern District of Ohio, where I served in the 70s. And he was a great source of counsel and other assistance as I was being considered for the court. Now, the late Judge Leon Higginbotham was a district judge when I was clerking for Judge Hasty. He later became an appellate judge. But when Judge Hasty died during the year that I was clerking for him, I turned to Judge Higginbotham for advice. He was the one who helped me decide that though I had submitted to work with a federal agency in Washington, D.C. after my clerkship, it was not the worst sin of all time to change my mind when a later opportunity became available in the U.S. Attorney's Office here in Cleveland. I have chosen for my topic, the topic of my lecture, Shoring Up the Constitution, The Legacy of the African American Lawyer and the Quest for Equality. My aim is to describe the calculated and challenging work that lawyers at the NAACP engaged in, which led to the Supreme Court decision in Brown versus Board of Education, the case that put legal segregation to bed, or at least started that process. It's in my view that the work that these lawyers did was so important to our constitutional jurisprudence that they are worthy of being called our second set of founders. I know I may be getting in hot water here, as the name of our so-called founders, Jefferson, Franklin, and Madison, and Adams, are sacrosanct. But I'll take the risk. Toward the end of my talk, I will take note of the various kinds of racial inequalities that still exist in our society. There have been many efforts to address some of these disparities. Some of them came in the wake of the George Floyd murder. But countervailing attitudinal efforts are underway that are complex legal challenges today that require the attention of dedicated lawyers like those who devised and executed the strategy that led to Brown. But before I get to the heart of my talk, I want to briefly give you a bit of my own background. I think this will shed substantial light on why I have such a personal appreciation for these Black legal pioneers and why I think their contributions were so seminal. Now, Professor Hardaway said a little bit about my background. She told you that I grew up in the South and that I grew up in segregated public schools. I'll tell you a little bit more. I grew up with my 5 brothers and sisters in the segregated South in a small town called Bessemer. It's right outside of Birmingham. I have often joked that when you grow up in a house with 11 other people, you quickly learn how to multiply and divide. If there are 12 donuts, you quickly learn, sometimes the hard way, that your share is 1. When we were growing up in Alabama, whites lived very close to us. Indeed, our backyard was back to back with that of a white family. They had no worries. They had their school and we had ours. They had no concerns about job competition from us. We could have no job they wanted. If we were lucky, we might work as a stock boy, but not at the cash register in the grocery store or as a salesperson in a department store. Blacks could not serve as bus drivers or police officers or in other than the lowest paying jobs in the steel mills. Everything was segregated from top to bottom. There was gross inequity in education. There are no blacks serving in local government. The doctor's office was segregated, one side for blacks and the other side for whites. Restrooms and water fountains were segregated. Blacks were segregated from whites on trains and other forms of public transportation. And on buses, blacks had seating, but only when available, and it had to be in the back of the bus. Even insane asylums were segregated, and racial intermarriage was strictly prohibited. Now, this is something you all know, you all heard of, but I'm going to tell you that this is the reality that I lived as I grew up. This segregation existed as a matter of law, not just as a matter of custom. Now, let me give you some sense of how things were even as things began to change. I want you to understand the context. Remember, it was early May of 1963 that Police Commissioner Bill Connor turned his police dogs loose on the freedom marches in Birmingham, many of whom were little children. You've heard of that, and maybe have seen some films of that. It was June of that same year, 1963, that George Wallace, the governor, stood in the door at Foster Auditorium at the University of Alabama in an attempt to prevent the registration of 2 black students, James Hood and Vivian Malone. Fortunately, the Deputy Attorney General of the United States was there, and on orders of President Kennedy, the National Guard was federalized, and the governor had to step aside. The governor stood in that door in fulfillment of a promise he made after his landslide victory in 1962. At that time, right after the victory, he stood on the gold star marking the spot where nearly 102 years earlier, Jefferson Davis, not Thomas Jefferson, Jefferson Davis was sworn in as the President of the Confederate States of America. Wallace stated on that occasion, this is 1963, "In the name of the greatest people that have ever trod the earth, I draw the line in the dust and toss the gauntlet before the feet of tyranny. And I say segregation now, segregation tomorrow, segregation forever." Can you imagine? But that was just 1963. Wallace's tone and words harken back to an earlier time when the former governor and later Senator of South Carolina, Strom Thurmond, the presidential candidate of the Dixiecrat Party in 1948, stated, "All the laws of Washington and all the bayonets of the Army cannot force the Negro into our homes, into our schools, our churches, and our places of recreation and amusement." And so, with the actions of Bull Connor, this is 1963 also, and the Thurmond-like protestations of Governor Wallace still in view, 4 cowardly members of the Ku Klux Klan took matters into their own hands, and on September 15, 1963, committed the heinous murder of 4 young girls who were worshiping at the 16th Street Baptist Church in Birmingham. Birmingham and the world should never forget Addie Mae Collins, Cynthia Wesley, Carol Robertson, and Denise McNair. Now, some of you may have noticed that just a few days ago, Justice Ketanji Brown Jackson was at the 16th Street Baptist Church, and she was there because of the anniversary, the 60th anniversary of that bombing of the church. And she said, really, that the horrors like those involved are difficult. They're difficult to remember and to relive, but it's also a danger to forget. And I so agree with what she said. 1963, again, I was in 11th grade when I was physically attacked, but not seriously injured, by a white gas station attendant in a small town in Georgia for using the only restroom there while traveling to a church convention with 2 deacons. The man who attacked me said he thought that we were part of a conspiracy by Robert Kennedy, the Attorney General of the United States, to integrate the South. My thought at that time was that the Attorney General could strike such fear and emotion in that attendant, then being a lawyer like the Attorney General might be a desirable profession for me. And again, I'll just close out kind of this background information with this. I was a senior in high school in 1965 when Viola Luzo, a white woman from Detroit, was shot as she drove some persons who had marched back from Selma to Montgomery. So all of that was captured before I finished high school, all of those things. It must be hard to imagine today, but that's what life was like when I was growing up. Now, I had some glimpse, but I really didn't fully understand at that time that there was a band of lawyers starting in the early 1900s who were dedicated to the eradication of legal segregation in America and to what the late Chief Judge William H. Hastie, the U.S. Third Circuit Court of Appeals, called an equalitarian legal order. This effort was led by Charles Hamilton Houston. He and others used the NAACP and Howard Law School as basis for an all-out attack on the then existing racist legal order. There were a number of black lawyers involved in this enterprise, but there were also some white lawyers. Prominently involved was Nathan Marigold, a Jewish American. He was retained by the NAACP in 1930s to do a comprehensive study of the legal status of the Negro, in quotes, and possible legal strategies for constructive change. Another person figuring in that strategy was William H. Hastie, I just mentioned, who was the judge that I clerked for. He was the first Article III judge on the federal court in the United States. He, like Houston, had graduated from Dunbar High School in Washington, D.C., was Phi Beta Kappa at the Amherst College, and was on the law review at Harvard Law School. He would later serve as a territorial judge in the Virgin Islands, as Dean of Howard Law School, as Assistant Secretary of War and as Governor of the Virgin Islands. And so he was one of those persons. And later, of course, Thurgood Marshall would become the lead lawyer in terms of the whole Imperial enterprise. Now, they had a whole host of things that they had to attack. And it's important to understand that historically. So racism and voting. Some of you heard about grandfather clauses and so forth. So early efforts to limit the right to vote by blacks included the so-called grandfather clauses, which extended the franchise without limit to those whose ancestors were voters, but placed burdensome restrictions on all other voters, mainly blacks. And so they had so-called white primaries, which excluded blacks from voting in the Democratic Party. And that was the only meaningful party in the South. And so it was not until 1944 that the Supreme Court invalidated white primaries in Smith versus Allwright. That was 321 U.S. 649, but 1944. Then you've heard about literacy tests. You may have seen the movie Selma. I think it was pretty accurately depicts the kind of tests that were imposed to restrict voting and used to restrict voting and poll tax, all of those kinds of things. So one thing after another, there was always something else that the lawyers had to turn to attack in that area. But racism and housing, again, they had to deal with that. So in 1917, Supreme Court had invalidated statutes and ordinances which directly prohibited blacks from owning or occupying residences in particular areas. But they didn't do anything to so-called restrictive covenants, and so those still existed. What are those? I think most of you have heard of them, but this is a circumstance where white owners of property, through restrictive covenants, contractually committed not to sell their property to blacks. And the theory was that this is not state action. That was the initial theory, because these are simply the parties themselves agreeing contractually to something. And so therefore there would be no ability to have those stricken down in the Constitution. But the Supreme Court finally held in 1944 that the court involvement in enforcing such covenants constituted state action in violation of the Equal Protection Clause of the 14th Amendment. And so those clauses were stricken down in that context. Let me just read you a little bit from the excerpt of testimony from a restrictive covenant case. It's Hurd versus Hodge. It was a companion case to Shelley versus Kramer, which is a case you probably heard of. So this exchange in a deposition kind of tells you the mind, or gives you a sense of the mindless nature of racism. Now the question was, now suppose, Mrs. Hodge, it was a very light Negro, say 99% so-called white blood. Her answer, it could still be a Negro, I think. Question, and would it not make any difference? Answer, no. If you got a person in the block who was supposed to be white, and that person was undesirable, in the sense of untidy or something like that, you couldn't do anything about it? Answer, no, certainly we couldn't. Question, and you would prefer that untidy white person to a Negro, no matter how educated or cultured? Answer, as long as they are white, I would prefer them. Question, no Negro, no matter how, whether he might be a senator, a congressman, would not make any difference to you? Answer, wouldn't make any difference. Even the white man who just came from jail, you would prefer him? Answer, because he's white and I am white. Now, the main thing I want to talk to you about is the NAACP's attack in the educational field. So I'm not going to say much about employment, but I gave you a sense of what employment was like by telling you there was no job that we could have if a white person wanted it. I think that's enough for now. But in terms of education, most of you have heard Plessy versus Ferguson, and that established a separate but equal doctrine as the law of the land. So The problem here was they were seeking to attack segregation education, but they had to deal with Plessy versus Ferguson. And Supreme Court had made it clear long after Plessy versus Ferguson in 1927 in a unanimous opinion that the requirement of segregated schools has been many times decided to be within the constitutional power of state legislatures. So it was pretty clear that they didn't have anywhere to go in that context of challenging the separate nature of the facilities. And so the initial approach was not to try to repudiate separate but equal doctrine of Plessy versus Ferguson. Their attack was on the inequality of the black educational system rather than aspects of the doctrine requiring separate facilities. And so they worked their way through that. And the first thing they did was to decide that the systems were vulnerable in the South because public funds were insufficient to maintain systems for blacks from elementary to college. And so they were pretty confident about that. And the first attack they made, the real attack they made, was on disparity in salaries. Black salaries were about 1/2 of competent trained white teachers. And so that was one of their attacks. And then the next attack, which I think is fascinating, was in the area of graduate and professional training. State-supported schools for black graduate and professional training was virtually non-existent. So they thought that ruling here would have a substantial impact. If blacks wanted an education, the thought was they would be entitled to it now, and not later after that. They began their attack. Now, basically what happened was when blacks applied to white state schools for graduate professional education, some states then said, we'll give you aid to go outside of the state. Because they had to supply an education. It could be separate. It's supposed to be separate and equal. And so most of you here who at Case Western Reserve University know of Fred Gray. He's been here many times, I know. He was quite a contributor to litigation in the courts relative to bringing about equality. But he was one of the persons that got a ride to Case Western Reserve University. When he went to Alabama to say, I want to go to University of Alabama, the answer is, you're not coming here, but we have some money for you. And so they sent him to Case Western Reserve University. There was another guy who was a famous civil rights lawyer named Horace Ward from Atlanta, and he did the same thing. And he went to Northwestern University. And so some of the blacks would take the money and go and get an education. And so they worked their way through that. But finally, there was a black student in a case called in Missouri, XRL Gaines versus Canada. That's the name of the case. He rejected the out-of-state scholarship. And so the question became, if you reject the scholarship and then they refuse admittance to the University of Missouri, what's going to be the outcome? And the Supreme Court overturned the lower court there and decided that they had to provide for him an education in Missouri. And so that was kind of the start of the process to break down separate but equal. And so the Supreme Court did that. The next case was a case called Scipio versus Regents of the University of Oklahoma. The University of Oklahoma refused to admit a black student on the ground that she would have, they said to her, you should have sued to establish a black school here. That's what you should do. And so we're not going to give you an education. The Supreme Court said, quote, the petitioner is entitled to secure legal education afforded by a state institution. The state must provide it for her and provide it as soon as it does for applicants of any group. And so what happened then? Once the Supreme Court said that, the Oklahoma legislature made a last-ditch effort, and they said blacks could matriculate at Oklahoma if no black institution existed, but their program of instruction shall be given in separate classrooms or at separate times. Now, the law school didn't follow that, but that's the law they passed after that case was decided. But there's another Oklahoma case because in that case, called McLaurin versus Oklahoma State Regents, that person was admitted to the School of Education at Oklahoma. He sat in a classroom now, classroom rows specified for colored students, and similarly segregated tables in the library and cafeteria. So they said, we'll fix you up. We'll give you an education right here in the same school, but we'll give it to you separately. Supreme Court, even the Supreme Court at that time concluded the conditions under which this appellant is required to receive his education deprives him of his personal and present right to equal protection of the laws. The point I want to make is that these lawyers really had to strategize. They really had to work from case to case to case to get to the point where they eventually got to Brown. And so the last important case was a case called Brown versus Sweat. Before Brown was Sweat versus Painter, and that was decided on the same day as McLaurin. This person sought admission to the University of Texas. He attempted to show that the state's law school for blacks, which was hurriedly assembled, was inferior to the University of Texas. He also sought to show that the educational experience and the professional training of a minority within a segregated institution could not be equal to the training and experience one would get in an unsegregated law school environment, an environment comparable to that which a practicing lawyer must deal in the courts, and his professional relationship with other lawyers. So he used some expert testimony in that case, utilized testimony of distinguished legal educators and administrators to show the court the essential characteristics of being a lawyer, competent lawyer, would require training that was not segregated, because that would be crippling in regard to the kinds of experience that one would need in order to be a competent lawyer before the bar. So the McLaurin case, which I mentioned before, suggested that if racial segregation in one institution was unconstitutional, that's where they had the person seating at different places within the same institution, there was no basis for maintaining it through requirement of separate institutions. And then the reasoning of Sweat regarding legal education suggested that there was no basis for adopting it in other areas of education. And so they were on their way to Brown at that point, after the Sweat versus Painter case. Now, I'm not going through the details of Brown, but I just wanted to give you, in capsule fashion, kind of the struggle that took place in terms of bringing these lawsuits. Now, it's hard to rehash them here in this time frame in a way that gives you a sense of how hard they worked, how much they strategized, how calculated they were in terms of choosing the cases that they would bring one after the other until they finally got to Brown versus Board. They couldn't get to Brown versus Board, as I pointed out before, at the time they started their attack, because separate but equal was so entrenched that they had to go step by step. Black institutions are separate, they are unequal. Sometimes they didn't exist with the graduate schools, and they really thought that the graduate school example was one of the best that would allow them to work a strategy that would eventually get them to Brown versus Board of Education. Now, Brown versus Board of Education was decided along with the case of Bolin versus Sharp. And the Brown case was a conglomeration of cases from across the country, Kansas and from down south. Bolin versus Sharp involved the District of Columbia. And so that drew in the due process clause, as a kind of a surrogate for the equal protection clause and the other cases. And so in Brown, just say a little bit about what the court said at that time. This is 1954. To separate black children of similar age and qualifications solely because of their race generates a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way unlikely ever to be undone. And that was bottom on social science research. The court was finally prepared to accept that argument. So separate facilities are inherently unequal. That's a phrase that you hear and have heard over and over. Now, Brown had immediate effect in other areas, but didn't really have immediate effect in some areas of the country relative to education. I grew up, as I said before, in Western Alabama, and Brown was decided in 1954. When I finished high school in 1965, Brown had not yet arrived. Now, they tried a couple of things, like the Freedom of Choice Plan. If you don't know what the Freedom of Choice Plan that is, it means that if you are a black student and you want to be the only one to go over, to the white institution and integrate, then you can do it, and vice versa. But you have to understand the context, because there was violent reaction to Brown versus Board, and so things were not hospitable. And so you can imagine how difficult a choice that would have been for someone to say, there's a black student, I'm going over to a white school. So it just took a long time. There are 10 of us in my family, and it wasn't until I'm number 4 from the top. It wasn't until the last 2 brothers, my youngest brothers, that schools were integrated. And that was about some 10 years probably after I finished high school or something like that. In fact, the University of Alabama at Birmingham had never had a black student by the time I started college in 1965. So this is not so long ago. And I think that's important to understand, that this is not a long history that we've had at legal equality. It has not a very long history at all. Now, you can imagine that after schools were integrated, then, or at least there was a basis for integrating the schools. There was law. Then that affected public accommodations, and then down the line, and then places of recreation, and so forth. But it wasn't easy. It wasn't an easy pass at all. So I just wanted to do a couple of other things. One, I wanted to say that basically these lawyers, and again, I haven't given you their backgrounds or detail and so forth, but they really were outstanding, and a number of them became federal judges over time, and outstanding lawyers outside of the NAACP Legal Defense Fund. But I do feel that their contribution is such that they ought to be highlighted, that they ought to be remembered, and that it's worth repetition, even if people know about their contribution. Now, there are, I said, I think, when I talked to Ms. Hardaway, that I would say a little bit about some of the areas that are kind of interesting areas now, without going beyond what a judge should do. And so, if you ask me questions, I may not answer. But some of you may have seen or been focused on the affirmative action cases of the last term. I just want to mention those a bit. Students for Fair Admissions versus Harvard, Students for Fair Admissions versus University of North Carolina. And most of you know that in those cases, the court rejected the approach endorsed in Grutter versus Bollinger, that race could be considered as one factor in making admissions decisions in colleges and universities. It's an important decision. We've been with Grutter versus Bollinger for quite some time. And in higher education, I know that we've counted on that case as being the law of the land. And so the question becomes, what what now? What effect will that have on education going forward? And what effect will it have on admissions going forward? And what effect might it have otherwise? Case was 6-3, opinion written by Justice Roberts. Now, Chief Justice Roberts said something that's very interesting in that case, and those who follow it will probably know about it, but you may not if you haven't followed the case. He indicated that sometimes race might be taken into account. After he said race could not be one factor, he says, nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. So he carved out kind of an exception there. And the question is it really an exception? And what does it all mean? And I'm here in the university now with you all, but the college that Ms. Bill Harway and I attended, I know we may not be at Grambling as much as the Harvards and the Yales and the larger universities, but we do give some attention to trying to figure out what does it all mean. And I've been reading the popular press and so forth about institutions and their response, and they've been scrambling to figure out how to revise their essays and what will they advise, and the counselors, what will they advise students to do in terms of putting information into essays, or should they just not do it at all? There's also been a question as to what has been the effect in California and Michigan, where they've had prohibitions regarding race before. I think the answer is that for the most part there's been a drop-off, especially in California, in terms of the number of blacks who are involved who are admitted to those institutions. And the question is, can socioeconomic status be a surrogate? Well, I think the answer is probably not completely. There is some overlap between socioeconomic status and race, but not completely. And so I don't think that many think that it can be exactly that. The other questions, does it apply to financial aid? Does it apply to other areas such as employment? There are a whole range of questions that are generated by this decision. Now, there's nothing to suggest in the decision that it goes beyond admissions, but there are lawyers who are formulating strategies to try to take that decision and use it as a way of eliminating consideration of race in other areas. And so the pioneers I talked about are not around to take on these questions, but we do need, and I think we have, a new generation of lawyers who would devote their minds and energy and time to helping to answer the questions in a way that can be legal within the bounds of the law, and yet work to advance the diversity that I think we all desire. And so it's going to be quite a task. Another area that I think affects African Americans and other minorities relates to so-called gerrymandering. Some of you may have followed congressional districting fight in Alabama. There was a Supreme Court case that came down this last June. It was divided 5-4. And they agreed, the Supreme Court, that Alabama had diluted the power of black voters because its congressional map only included one majority black district in a state that had 27% blacks. Now that's a simplification of the decision, but basically that's what happened. And so they sent it back down. In July, Alabama produced a new map, again with only one black district, appearing to be in open defiance of the Supreme Court. I mean, you'd have to make that decision for yourself, but that's what the popular press is saying. And the three-judge panel that oversaw the case beforehand said it was on remand, as it looked at the new map, disturbed by Alabama's actions in the case. It invalidated the map and appointed a master to draw new maps. And what did Alabama do? They filed an emergency motion through Judge Thomas with the Supreme Court. So I can't say that this case is shades of Gomillion versus Lightfoot, but those of you who know this area of the law, I was just reminded of it. It's a case that goes back to 1960 before the Supreme Court. It was a gerrymandering case, and it was an extreme one. And Fred Gray, distinguished alumnus of this law school, was one of the lawyers that argued that case. But in that case, the Supreme Court held the district boundaries drawn by the Alabama state legislature around Tuskegee, Alabama, which is primarily, if you know it, mostly black city. Blacks outnumbered whites there by large numbers, but the court found that the way they'd drawn the map was unconstitutional. It was done in the state legislature with no debate. It created a 28-sided city boundary that excluded nearly all black voters from the redefined city, but no whites at all. The bill was written by a state senator who was executive secretary of the White Citizens Council of Alabama. Needless to say, a white supremacist. And so that's the kind of gerrymandering that took place back at that time. But today, it's certainly an area of extreme concern as it relates to not only with regard to minorities or blacks, which I would say is very important, but generally. But in regard to African Americans and other minorities, it's certainly a way that can and will dilute the vote, and really need competent lawyers fighting those kinds of battles. There are other areas, there are other fights in the area of voting which relate to access to vote, staying current on voting rolls, amount of time you get to vote, all those kinds of things. There are a host of restrictions that are rearing their head. And so, again, I just only mention them because the NAACP, through the Legal Defense Fund, was fighting a battle across many areas, as I said before, housing and voting and education and so forth, and actually in the criminal justice area as well. And we have more now public interest groups and organizations and law schools are devoting time in their clinics to these kinds of issues. But I think this is well deserved, and I think that we need more of that in order to make sure that our institutions provide the kind of protection for its citizens, all of its citizens. So let me make some observations before I close. My view that the nation owes a tremendous debt of gratitude. Houston and Hasty and Marshall and the other legal pioneers who worked to extend the ideals of the Constitution and the Declaration of Independence to all of its citizens. And they did it at a great sacrifice and danger to themselves. And there were many others, including litigants, who also put their lives on the line. The work of these lawyers, in part, sparked the civil rights movement, which in turn was a catalyst for legislative changes reflected in the 1964 Civil Rights Act, the 1965 Voting Rights Act. Much has been accomplished. I can vouch for that personally. No one would have betted a plug nickel when I was growing up for my chances to become a United States District Judge. But great disparities still exist in the prospects and opportunities for a black child in comparison to a white child. We can't be satisfied with these outcomes. Of course, we must rely on the laws which protect us from discrimination, and we must work to design programs and institutions in ways that would generally advance opportunities for blacks and other minorities. And I think we should embrace diversity, equity, and inclusion efforts like the many institutions did in the wake of George Floyd's death. That is, to look at all of our actions and those of the institutions we serve through a lens of racial equity. Beyond this, we must as a nation continue to wrestle with our past and its meaning. It cannot be out of sight, out of mind. We must be openly intolerant of the kind of virulent racism and disregard for the law that is being both quietly and openly encouraged today. We must rise up as a nation to reclaim the moral high ground, recommitting ourselves to each other through word and deed, to equality, fairness, and opportunity for all of its citizens. And that will be should be bottom on the notion that what we share in common is that as human beings, we are all of equal worth. So, this is not the first time I will raise the flag for these outstanding lawyers, because I think without them, we would not have made the progress that we've made today. But there are so many things that we need to do, not all in the field of law, in order to make sure that the promise of the Constitution and the Declaration are real to all of its citizens. So thank you very much.
I was remiss in not inviting you all to the reception that will be in Ben's place after the Q&A, which begins right now. I'm going to turn the mic over, but if you have a question for Judge Oliver, please, by all means, raise your hand and we'll bring the mic to you.
Thank you very, very much. Truly, Judge Oliver, an honor to have heard you. I simply, before asking any questions, I want to exhort everyone in this room to go to Cleveland Playhouse and see Thurgood, the story of Thurgood Marshall. Don't miss it. We went with friends a few nights before today. My students all know I have truly encouraged them. It is truly phenomenal one-man show, a monologue that brings to life Thurgood Marshall and beyond Langston Hughes, the poet, and what poetry meant to Thurgood Marshall in his struggle along the lines you have exposed. So yeah. Please go to Thurgood, Playhouse Square, Cleveland, Ohio.
I'm going tomorrow. And my wife and my staff.
Thank you for doing so.
Judge Stone.
Your Honor, thank you very much. One of the popular academic memes, more than meme, in criticizing the Brown decision was to say, oh, things were changing. They just should have been more patient. And to me, what you have just recounted, I mean, it was that's beyond a bogus argument, and it pays no attention to the evidence that you've adduced today. In my judgment, I'd really welcome your thoughts on that line of academic response to Brown, which came. It was a latter day response. I mean, it's been in the last 15 to 20 years.
They thought that things went too fast?
Right. They say, you know, well, I mean, the problem with Brown was that it was forcing people, and they should have been more patient because things were actually evolving and changing.
Oh,
You know, and having been one of Judge Battisti's law clerks in the liability hearing of the Cleveland case.
No, I don't. Some things were changing in the country, and I think that was a good thing in the '60s. At that time, initially, it was a North versus South kind of thing, where people saw what people were doing in the South, and they said, "How can they do that?" In Northern institutions, some of them colleges and so forth, said they will take more black students, so that kind of started some positive things in that regard. But no, I don't know. There's no way waiting. There was no indication that the South was not prepared. Longer they waited, I think the longer the wait, the less likely anything was going to happen. They talk about all deliberate speed. The criticism has been with that language because it gave too much wiggle room. But I can tell you, I just pulled out the pages that I had as part of the talk and put them aside. But I had some pages on the reaction to Brown, and boy, was it virulent. The people who were involved as litigants, some had to flee town. One of the lawyers, Julius Chambers, place was burned down. It was a tough road, but I don't think the road would have been any easier if they waited. I just think they had to move. If where I grew up is any indication, they waited. They waited and waited and waited. So I think that the mood of the country had to change to make that kind of activity undesirable. They had to be shamed. I guess the best way I can put it. I'm not sure people can be shamed though if they have been on that. So I don't mean to go on and on, but no, I just don't see that. Yes.
You explained how leading up to Brown, there needed to be many different precedents overturned in order to build up to this case. But then recently with, some might argue that in Dobbs, the Supreme Court ignored a lot of precedent and kind of overturned it quickly, which set a new kind of precedent of ignoring precedent. So my question is, in that new judicial climate, do you think that changes things and makes it easier to not just roll back rights, but to protect other people's rights that haven't been there before?
Yeah, I don't know if I have a direct response to your question, but I do feel that as lawyers, these are the kinds of assessments you have to make. And so that puts you in position of being like the lawyers in Brown to say, you know, can I attack this frontally? If I can't, then are there other incremental kinds of things that we can do to achieve the same outcome or result? But I don't have any direct comment on that.
Hi, thank you so much for your talk. I'm wondering, when you were speaking, you were talking a lot about the ways in which we saw voting rights being blocked in the 60s. I'm wondering now, how do you feel people can promote political efficacy? Because I think amongst my generation, people have this sense of cynicism, like, what's voting gonna do? You know, so I'm just wondering, you know.
What voting's gonna do? I can tell you.
Well, I know, but I'm saying more broadly, you know, people have a cynicism towards voting. So I'm just wondering, you know, how do we combat that?
So I understand what you're saying. So when I said something that sounded like a joke, it wasn't meant to be.
Don't worry, I took it as a joke.
But because I do see and hear this from younger people,
Right.
much younger than I am, and there is a concern that people, including minorities, may not turn out to vote,
Yes.
even in a national election. So first thing, I think is sad, because I think that, you know, you can't just advocate. Really look at the candidates, look at the results, and really decide for yourself whether you think one candidate is more desirable than another. But just to throw your hands up and say, look, I'm not going to do anything. I mean, are you saying you're just ready to let the whole world go? I mean, that sounds like to me kind of where a person is when they say that. It's like, I don't care if it's this presidential candidate, I don't care if it's the other, it's all the same. And I guess, to me, there's more texture than that. And so I think the young people have to affect young people. That you gotta have young people who are committed to voting be a catalyst for other young people to join. I think. I think the other thing is you can join efforts to oppose restrictions on voting that you think will limit the right to vote of minorities. And not all states have those engaged in them, but there are a good number of states that in recent years have been putting more and more limits. And the argument is, I think it's a correct one, that it has a disproportionate effect on minority voting. So again, it's another way of diluting the vote. You know, you can think about litmus tests or a poll, but the other is just, you know, make it a little bit harder for them to get out. Make it harder to do absentee ballots. You know, give them fewer days before the election in terms of the days that they can vote leading up to election. It's a whole range of things. They also, well, let me stop there. It's on two levels. One is, come on, let's go. You look at it hard. And the second is that you've got to be. Why don't you be the catalyst? And I think we'll have to have some leadership from the young. I don't think I can see how it could be down and out or feel like it's not like what I want. I don't feel that way either. That the world is like the way I want it. I really don't feel that way right now. But I think that's not a reason to just give up. It's a reason to push forward.
Thank you all for attending. Again, the reception.